Let's look at some other cases involving common mistake. In Strickland and Turner, the transaction concerned life insurance for someone who had already passed away at the time that the agreement was made. Thus, the agreement was held to be void for common mistake. Very much the same scenario played out in Scott and Coulson, where again, a life insurance policy had been taken out for someone who had already passed away at the time that the agreement for the insurance policy was made. Again, the contract was held to be void for common mistake. However, as McRae and the Commonwealth Disposals Commission shows us, it may be possible for a contract to stand in spite of the fact that whatever the contract is about does not exist. McRae was hired by the Commonwealth to salvage a ship which had allegedly sank off the Australian coast. When McRae went out to do the salvaging, they found that there was no ship. The Commonwealth said that this was a situation of a common mistake. Both parties had believed that there was a ship to be salvaged, and both parties were wrong. However, the court said that it was really only the Commonwealth that believed that there was a ship to be salvaged, because McRae had no way of knowing that at the time that he concluded the agreement to salvage the ship. Thus, McRae was just relying on whatever the Commonwealth was saying. There was no actual shared belief that this ship existed. The contract was held to be valid, and McRae was able to successfully sue for damages. The next case is Frederick Rose and William Pym. Here the two parties had agreed on the sale of Feverols. Both parties believed that Feverols were basically horse beans. What both parties did not know is that Feverols were only one particular type of horse bean. When another type of horse bean was delivered, the buyer refused to honor the contract. The court held that because there was agreement to the effect that both parties thought that the contract was about horse beans, the contract was not void for mistake. As with some of the previous cases, the parties in Frederick Rose and William Pym held a mistaken belief regarding a particular quality of the subject matter of their contract. However, this was not sufficient to destroy the identity of the subject matter altogether, and hence the contract stood. In Harrison Jones and Bunt and Lancaster, the parties had agreed on the sale of something called Calcutta Kapok, and it was supposed to be of a particular brand, the Sri brand. When the Sri brand Kapok was delivered, the buyer found that it was not what he was expecting. He thought that the Sri brand was pure Kapok, but instead it was Kapok mixed up with cotton. Both buyer and seller, at the time the contract was concluded, had felt that the Sri brand Kapok was pure Kapok. Thus, they'd obviously made a common mistake as to a particular quality of what was being sold. However, this did not destroy the identity of the subject matter of the sale. In fact, the documentation clearly provided for the sale of a particular amount of Sri brand Calcutta Kapok, and that is exactly what was sold, and that is exactly what was bought and delivered. Thus, the contract was not void for common mistake. Finally, let's have a look at one of the rare occasions where a contract was in fact set aside for common mistake as to subject matter. This happened in the case of Associated Japanese Bank and Credit du Nord. A crook called Bennett had concocted a scheme whereby he approached the Associated Japanese Bank and asked for a credit of £1 million in order to buy 4 machines. The machines would be owned by the bank, and Bennett would lease them from the bank in return for monthly payments. But Bennett never bought the machines. In fact, the machines never even existed. What happened was that he took the £1,000,000 and disappeared. Luckily for the Associate Japanese Bank, or so they thought, they'd had an agreement with Credit du Nord, which is another bank, as a form of reinsurance. In other words, the two banks had an agreement whereby if Bennett did not pay his lease installments, then the Japanese bank would be insured against that with the Credit du Nord bank. So when Bennett disappeared with the money, the Associated Japanese Bank made its claim against Credit du Nord. Credit du Nord claimed that this was a case of a common mistake, and that the contract between the banks was void. Normally, as we have seen with so many of the preceding cases, the courts would find that such contracts are not void because although something has changed, the identity of the subject matter has not been destroyed. That, of course, is the test we remember from Bell and Lever Brothers. Here, the court found that the identity of the subject matter had been destroyed. Whereas before, when the two banks came together to reach their agreement, the subject matter could be described as a guarantee for 4 machines. In reality, the subject matter was a guarantee for non-existent machines. And so these two are fundamentally different, and therefore the court held that the identity of the subject matter had been destroyed and the contract was void. The Associated Japanese Bank was not entitled to the £1,000,000 from Credit du Nord. Let's move on to the second type of mistake in law, mutual mistake. A mutual mistake occurs where the parties to a contract think that they are agreeing to something different. One party thinks that they're contracting about one thing, and the other party thinks they are contracting about something else. They're both making a mistake, but it's not the same mistake. In other words, there's no meeting of the minds between the parties. And as we know from Contract Law 1, if there's no meeting of the minds, there is no contract. Whether there is a mutual mistake in law, and whether the contract can be set aside, depends very much on an objective test of the circumstances. The courts do not ask what was going on in the minds of the parties concerned. Rather, the courts ask, what would a reasonable man have thought if he had been there at the time the contract was concluded and if he had seen the contract negotiations unfold? Thus, there are only really 3 options how this can unfold. Let's say Party A and Party B reach an agreement. However, there is no meeting of the minds because Party A intends the agreement to be about X and Party B intends for the agreement to be about Y. A reasonable man could conclude that, looking at the situation objectively, it is clear that the parties actually meant X. In this case, the contract would stand. Alternatively, a reasonable man might conclude that what the parties meant objectively was Y. Again, the contract would stand. The third option is that the reasonable man would say, it is simply not clear whether the parties meant X or Y. There's just this ambiguity which cannot be overcome. In that circumstance, the contract would not stand, the contract would be void for mutual mistake, because there was no meeting of the minds. Let's have a look at some examples. Wood and Scarth, there was a tenant and a landlord. Their agreement was for a property to be let to the tenant for £63 per year. However, the landlord intended for there to be a special premium on top of the £63 of £500 a year. The tenant thought that the £63 was the final payment. Thus, both parties made a mistake as to the terms of their agreement. The question was there a meeting of the minds? Applying the objective test, the court held that the situation was not sufficiently ambiguous to void the contract. In fact, looking at it objectively, it would seem as if the terms of the agreement were for £63 per year, and so the tenant won the case. A contrasting case is Raffles and Wickelhaus. What happened in this case was that Wickelhaus agreed to buy some cotton which was going to arrive on a ship. The contract stated that the ship was called Peerless, and the words that were stated in the contract was that the cotton would be arriving on a ship called Peerless from Bombay. So these three words were evident in the contract: Peerless from Bombay. However, there were two ships called Peerless that sailed from Bombay. One in October and the other one in December. Again, applying the objective test, we ask ourselves, which version is more likely to be the correct version? Should the buyer have known that the ship was going to arrive in October, or should he have known that it's going to arrive in December? In fact, this is one of those situations where the ambiguity is so strong that the contract was set aside for mutual mistake. In other words, there's no way of resolving the matter. There's no way that an objective test can lead to finding that it should have been the October ship or it should have been the December ship. It's simply not clear. We simply cannot answer the question, and thus the contract was void for mutual mistake. Smith and Hughes is of course a case that you are aware of from Contract Law 1. In Contract Law 1, we talked about Smith and Hughes as a case that shows us that we need to apply an objective test when it comes to assessing the parties' intentions or the parties' conduct when they conclude an agreement. Here we look at Smith and Hughes from a mistake perspective. Remember, Smith and Hughes was for the sale of oats. Smith had showed Hughes some oat samples, and Hughes ordered a particular number of oats. When they were delivered, Hughes was not happy because he felt that those were new oats and he could not use them. What in fact he had wanted was old oats. However, the sample he'd been shown was new oats. The court held that there was no fundamental mistake as to the terms of the contract, and so the contract was not void. Tamplin and James was a case about the sale of a property at auction. There was an ambiguity as to the size of the lot that was for sale. In the end, the court decided that, looking at the situation objectively, the buyer should have known about the correct size of the lot, and the contract was held to be valid. Scriven Brothers and Hindley also involved a situation of sale at an auction. Here, the sale was for rope. The buyer believed that the rope was made of hemp, when in fact the rope was made of tow. And as hemp was more expensive than tow, the buyer bid a very high price. The court held that the contract was not valid because the auctioneer had induced a mistake. Let's move on to the third type of mistake, unilateral mistake. Unilateral mistakes occur where only one party makes a mistake, but the other party knows of the mistake. There are two instructive cases that we can look at. First, Hartog and Collin and Shields. Mr. Hartog wanted to buy hare skins. So he agreed with Collin and Shields to buy hare skins at a particular price per skin. That means per piece. However, when the administrators at Collin and Shields prepared the final contract, the written contract, instead of having that price per skin, they had put down that price per pound. Now, since one skin weighs a lot less than 1 pound, that meant that Hartog was getting a much better deal than what he initially thought. The court held that Collin and Shields had made a unilateral mistake and that Hartog knew about it. This rendered the contract void for mistake. Crucially, in the eyes of the law, the mistake here was a mechanical mistake. Collin and Shields had simply typed in the wrong word. They typed in pounds rather than skins. Had they made a business error, the contract would have been valid.